Okay. Good evening, everyone. This is Advocate Gurpreet Singh. I welcome you on behalf of our panel, the Nani Palkhivala Law Club. In this club, we offer lecture series wherein we offer insights to the life of personal life and professional life of legal stalwarts, which is exclusive in itself. And by doing so, we inspire young lawyers and practitioners to aim and inspire for such journey. A quick instruction to our viewers that you please join with your own name so that it's easy for us to identify you. And next, I am very much proud to announce our host, Mr. Jayprakash Somani. He's a practicing Supreme Court advocate, and he has more than 30 publications in his name. And over to you, sir.
Thank you.
Yes.
Thank you, Gurpreet. Welcome all. What is the purpose of this Nani Palkhivala Wednesday Law Club's formation? So let me tell you, I want to give the talent of India's talented people who are sitting in Delhi, senior lawyer, living legend like Jaideep Gupta sir, so many senior lawyers are there. But we are getting their benefits, we are getting their surroundings. But I want to give this surrounding to all India. पूरे भारत को हम ये देना चाहते हैं क्योंकि हम जो जितने भी चार हम यहाँ की एग्जीक्यूटिव बॉडी में हैं इसमें पीएच चंद्रलेखा है, हर्षवर्धन सिंह राठौड़ हैं, हमारे पीयूष हंस हैं, ये चारों की चारों हम ओरिजिनल दिल्ली के नहीं है। मैं महाराष्ट्र से रूरल एरिया से हूँ, टाकलीबान तालुका श्रीरामपुर जिला अहमदनगर महाराष्ट्र। चंद्रलेखा उड़ीसा से हैं, हर्षवर्धन सिंह राठौड़ जो है ये हिमाचल प्रदेश से हैं, और हमारे हर्षवर्धन सिंह राठौड़ इंदौर से हैं, और पीयूष हंस से हिमाचल प्रदेश से हैं। तो ये हम बाहर के हैं, लेकिन हमने यहाँ पे जो सुप्रीम कोर्ट में प्रैक्टिस करते समय जो पाया है, ये भारत के सभी लॉ स्कूल को अगर मिलता है, भारत के सभी लॉयर्स को अगर मिलता है, तो क्यों नहीं किया जाए। इस उद्देश्य को रख के हमने नानी पालखीवाला वेडनेसडे लॉ क्लब की स्थापना की है। But why I have given this name of Nani Palkhivala Wednesday Law Club? Because Nani Palkhivala is my hero. He is hero. He has argued in Keshwananda Bharati case very fantastically. If you see his argument in that judgment, if you see the everything and basic structure doctrine properly is the output of that Keshwananda Bharati case. And at the time that time's government want to destroy democracy, basic structure of our fundamental right. So they put the review petition on Keshwananda Bharati, but review petition also in such a way Nani Palkhivala argued that is so much credit goes to Nani Palkhivala to save our democracy. And in another effort also, the government of at that time in a Minerva bill case also, they tried to destroy it, but no. So democracy, our constitution's credit goes to the institution, Supreme Court of India, all judges, the credit goes to all judges. Nani Palkhivala, one-man army who fought at that time. So Nani Palkhivala is my hero. There are so many his good things which I can mention later on in some episodes. So हम यहाँ पे अभी थोड़ा सा आपको बताते हैं कि आज के जो हमारे चीफ गेस्ट हैं डॉक्टर जयदीप गुप्ता, हम यहाँ पे सीनियर लॉयर हैं सुप्रीम कोर्ट में, बहुत अच्छे नेशनल इंटरनेशनल लेवल पे इनके काम होते हैं। जयदीप गुप्ता, who is a speaker, has been handling commercial and constitutional litigation for over 30 years in Supreme Court of India. 30 years इसको बोलते हैं दोस्तों. And high courts across the country. He was born in 1961 into a family of lawyers in Kolkata. After obtaining a first class in economics from the university in Kolkata in 1981, he read for the law typos in the University of Cambridge and then qualified for the English bar from Lincoln's in 1985. After completing his education, he started practicing in High Court of Kolkata and subsequently in the Supreme Court of India. He was designated as a senior lawyer in 2002. He has frequently appeared before international and domestic arbitral tribunals. He has a regular participant and speaker at the Commonwealth Law Conference since 2011, at the Cambridge Symposium on economic crime since 2013. He is regularly delivering the lectures at international level. ऐसे आज इसलिए मैंने उनको लाइव लेजेंड बोला है. ये हमारा भाग्य है, हम इनको एक दूसरे को मिलते हैं, हम कॉफी साथ में पीते हैं, ये हमारा भाग्य है. जैसे भगवान सामने रहते हैं, भगवान के साथ घूमने में जो एक आनंद आएगा ना किसी को, ऐसे हैं हमारे सुप्रीम कोर्ट के जयदीप गुप्ता सर. तो इनके बहुत सारे और भी काफी बायोडाटा इनका बड़ा है, लेकिन मैंने बहुत क्लिप्स से इसको पढ़ा है. चलो दोस्तों, आज का ये प्रोग्राम शुरू करते हैं. आपको मालूम है कि हमारे जयदीप गुप्ता, सीनियर लॉयर जयदीप गुप्ता सर, ये बहुत अच्छे स्पीकर हैं. एक्चुअली हमारा ये प्रोग्राम इंटरव्यू फॉर्म में है, लेकिन मैं बहुत सारे बीच में सवाल पूछूंगा ना, तो एक अच्छे स्पीकर का जो फ्लो है ना, वो फ्लो ब्रेक हो जाता है. इसलिए आई विल पुट ओनली 2 क्वेश्चंस इन फर्स्ट सेशन. एक क्वेश्चन का 15 मिनट में वो जवाब देंगे, दूसरा क्वेश्चन का 15 मिनट में जवाब देंगे. लेकिन वो स्टार्ट में ही मैं 2-3 क्वेश्चन जो पूछना है मुझे कमर्शियल कोर्ट के ऊपर मैं पूछ लेता हूं. सो जयदीप सर, व्हेन गवर्नमेंट ऑफ इंडिया नीड्स टू ओपन दिस कमर्शियल कोर्ट्स, before commercial courts, all litigation of financial matter goes to regular civil courts. When commercial courts comes into existence, and what is the purpose of this, and which type of commercial courts are there? So we want to, on all India's legal fraternity and all India's legal students want to listen about commercial court from you, Jaideep sir. Now, mic is towards.
Namaskar. Advocate Jayprakash Somani, it is a pleasure to interact with you on this platform, as we do in our coffee room in the Supreme Court, as you said. Your very kind words. Thank you very much. You see, in a sense, 2015, after many years, was a watershed year for dispute resolution, at least civil dispute resolution in India. Civil dispute resolution in India is primarily litigation in courts and alternative dispute resolution mechanisms like arbitration, like mediation, conciliation, etc. In 2015 or thereabouts, the actual date on which each of these legislation came about is a little different. But around that time, at least 2 major initiatives were taken, which to my mind has changed the landscape in this country. And these 2 steps, there were 2 others also, which are less important from the point of view of procedure. But these 2 steps included the Commercial Courts Act of 2015 and the amendment to the 1996 Arbitration and Conciliation Act, also in 2015. Very significant amendments of the arbitration law took place by the 2015 amendment. Now, these 2, between them, have the intention, and of course it takes time for any such intention to get translated into reality. The intention is to streamline and expedite commercial dispute resolution in India. And the primary goal here is to make the industry more competitive. The ease of doing business concepts are involved here, which became a priority with the government of India over a period of time. And so therefore, this legislation, these 2 legislations were expressly with the object of making India a higher rank holder in the sphere of ease of doing business. The other two legislations which also achieved something of the same, one is the IBC, that is the Insolvency and Bankruptcy Code, and the other is certain other amendments to the Companies Act in 2013. But if we focus on the purpose of the Commercial Courts Act and the amendment to the Arbitration Act, we see that there is an attempt here, and a very definite attempt, to expedite and streamline the process of commercial dispute resolution. That is the entire emphasis of this 2015 exercise in these two, both these two spheres. Now, as far as the Commercial Courts Act is concerned, you're right in saying that civil disputes have been the subject matter of the civil courts in India from before independence and has continued after independence for more than 100 years that has been in place. We have a very sophisticated civil procedure code which takes care of a very wide range of situations and lays down a procedure by which you can resolve a civil dispute. But civil disputes of a particular kind, that is of the commercial nature, is of specific relevance because of the fact that unless and until you have a quick resolution to commercial and civil disputes, investment is difficult in this country. Particularly if you wish to attract foreign investment into India, it is very important that they have the assurance of a quick resolution mechanism in this country, which allows us to quickly resolve a commercial dispute. Because a commercial dispute which cannot be resolved is very damaging to the industry, to investment opportunities, to the entire commercial world. So the purpose of the Commercial Courts Act was to streamline the court system as far as commercial dispute resolution is concerned. Now, different countries in the world had over a period of time adopted commercial courts as a specialized court. It is specialized in the sense that the judges concerned are specially trained to deal with these disputes. That is the position even in our country, in the Commercial Courts Act. The second thing about these Commercial Courts Acts which had come up around the world was that whatever best practices had been developed in the matter of civil procedure, those were being adopted. How can you make the procedure more streamlined and quicker? We adopted a whole lot of this from the UK, and this will be apparent from two of the reports of the Law Commission which preceded the Commercial Courts Act. And the Commercial Courts Act which came in was based to a large extent on research done on similar commercial courts which had come into operation in the rest of the world. UK, Singapore, and many other countries had started adopting these. It is interesting to note that today there is a body, international body, whose focus it is to collect all the best practices from commercial courts across the world and collect that information and make it available to everybody so that everybody can be benefited by that. Now, if you look at the Law Commission reports which preceded the Commercial Courts Act, it was said that we are modifying the Civil Procedure Code and trying to streamline it for the purpose of commercial courts. But this is not the end of the exercise. If this model of the Civil Procedure Code works, then we would like it to become available for all civil jurisdictions in the country. What the Commercial Courts Act does is it modifies a large part of the Civil Procedure Code in a schedule. The schedule says that the Civil Procedure Code is modified in these respects. And this is a model. If this model is acceptable and if it works, then it will not only be used for commercial litigation, but it will be used for all civil litigation. So therefore, there is a forward-looking and far-reaching effect that this legislation has. It is not only a legislation to create a commercial code, but it is also an experiment which is not restricted to commercial courts. It is an experiment which is a step forward for the entirety of civil litigation in this country.
Yes.
So therefore, this is how it has started. The idea was that specialized judges would be picked up and they would man the civil courts, certain civil courts in this country, which will only handle commercial disputes. The Act says what are commercial disputes. The Act says that commercial disputes include disputes with the government of India or with the government of a state. It's very important because the idea is to expedite. Now, what do we do nowadays? If we have a commercial dispute with the government, we tend to file a writ petition under Article 226, only because it is a more effective and more expeditious mechanism for resolving the dispute. But we know that it is a slightly cumbersome way of doing this because the writ jurisdiction has its own restrictions. It's actually a judicial review mechanism. It is not supposed to go into disputed facts. It is not supposed to go into various aspects like contracts and all that. So therefore, it's a kind of stopgap arrangement that is going on because we have nothing better. The Civil Procedure Code is taking too long to deliver justice. Commercial Courts Act intends to cut down the time frame for resolution of commercial disputes. If it does so, and if this includes commercial disputes with the government, then you will not have to file writ petitions in order to resolve disputes between the citizen and the government in the sphere of commercial law. So tender cases, government tender cases, by definition, come under the Commercial Courts Act. And if the commercial courts are able to work in the way that they are supposed to work, if they are able to deliver justice quickly, then soon or at some stage you will find that it is not necessary to file writ petitions in order to get relief in respect of a dispute between the government and a private citizen. This question of disputed questions of fact only being restricted to procedural irregularities and not being able to handle the substantive nature of the matter, all these will disappear, and it will be possible to resolve disputes between the citizen and the government in a commercial sphere, because the government is heavily into commercial sphere now. It's no longer, it's not worthwhile taking a position that the government is not interested in business. Government is in business, government is interested in business, and everybody has to do business with the government. So this is how the Commercial Courts Act has come into existence. The original idea was that disputes above 1 crore must be placed before the Commercial Courts, But now the understanding is that no, why are we going to leave out the small businesses from this? After all, the emphasis today is medium and small industries. The MSME concept, which is very, very vibrant now.
Yes, yes.
Why should we leave them out? So therefore, by way of an amendment, the limit has been brought down to 3 lakhs. 3 lakhs is a figure which really addresses small businesses in the medium or smaller towns of India. It's not meant for a Delhi businessman, but it is certainly a relevant figure for a businessman in, say, Sholapur or in Bardhaman in West Bengal or Tanjore in Tamil Nadu or places like that. So yes, there was a resistance to it from the judges. The judges felt that after all, we are not increasing the judicial strength merely because the Commercial Courts Act has come in. The same judges, a group of them were being trained to specialize in it, taking them away from deciding, let us say, criminal cases, or taking them away from deciding cases which deal with the poorer sections of society, labor issues, other issues which are of burning nature. Now, they felt that it is all right so long as the jurisdiction is 1 crore and above, because then a certain amount of judges would be required. If you bring it down to 3 lakhs, even more judges will be required in order to make it feasible. So they felt that this would only take away judicial resources from other sectors. But I think that the feeling was that we are at a stage in development of this nation when it has become necessary to focus on doing business at even at a smaller level. It has become necessary that our economy gets the total priority, because only by giving priority to the economy are we ultimately going to be able to pull up the poorer section of the society. The poorer section of society cannot be directly benefited through, let us say, government handouts, etc., for any sustainable length of time in the future. The only way that you're going to be able to uplift every aspect of society is if economy and commerce flourishes in this country at all levels. So with this kind of a vision, I think, they have reduced it to 3 lakhs, as a result of which down to the district court, to the lowest, to the smallest business venture, because after all, in today's money terms, small contracts, 3 lakhs represent small contracts. It doesn't represent very large contracts at all. Yes. So this is the way that the commercial courts have come into existence and has spread across the country. Every district court has to isolate and appoint judges who are specialized in this, and they are called the commercial courts of this country. They are subject to one level of appeal, and they require to function in manner which is a streamlined version of the Indian Civil Procedure Code, and various best practices of that are followed in various courts are all collected in this legislation, so that everybody may avail of the benefits of it.
In very nice way you explain everything. बहुत अच्छा लगा. Our debt recovery tribunal, DR80, NCLT, NCLT are also working very finely, and in fast way disputes are resolution of all dispute is going on. थोड़ा सा कुछ वैकेंसीज भरना बाकी है, वो अगर हो जाता है तो ये और तेजी से चलेगा. बहुत अच्छी इंफॉर्मेशन मिली है ये चीजें, और YouTube के माध्यम से जब ये YouTube पे जाएगा तो कभी भी लोग इस ये इंफॉर्मेशन को एक्सेस कर पाएंगे, देख पाएंगे. मैं दर्शक को बताना चाहता हूं कि जयदीप गुप्ता सर ये खाली वकालत के साथ साथ वो हम जो सुप्रीम कोर्ट में लॉयर जो यहाँ पे प्रैक्टिस करते हैं, एवार जिसको बोलते हैं एडवोकेट ऑन रिकॉर्ड, इनके भी वो टीचर है. एडवोकेट ऑन रिकॉर्ड के एग्जामिनेशन के समय उनके जयदीप सर के लेक्चर्स रहते हैं. इफ यू गो ऑन ACBA वेबसाइट और इफ यू गो ऑन एवार वेबसाइट, यू विल फाइंड हिज लेक्चर्स ऑन एवार सीरीज ऑल्सो. Jaideep Gupta sir, I want to now turn towards the arbitration, international arbitration, national arbitration, international arbitration. Both arbitration are coming into Arbitration and Conciliation Act. मेरे आर्बिट्रेशन कॉन्सिलेशन एक्ट के ऊपर एक वीडियो भी है, किताब भी है कुछ सुप्रीम कोर्ट की केस लॉज के ऊपर. और लेकिन बहुत मैंने आपके बारे में सुना है कि इंटरनेशनल लेवल पे आर्बिट्रेशन के लिए आपने काफी काम किया हुआ है, एंड उसके बारे में भी आप इंटरनेशनल आर्बिट्रेशन के बारे में बताइए कि भारत के लॉ स्टूडेंट स्पेसिफिकली कॉर्पोरेट फील्ड में जो जाना चाहते हैं वो आर्बिट्रेशन के बारे में बहुत अच्छा जानना चाहते हैं. और इसके साथ साथ आई रिक्वेस्ट यू शेयर योर एक्सपीरियंसेस आल्सो, personal experiences also in international arbitration as well as in international Commonwealth speech, Commonwealth stage also. Share your experiences also, sir.
Thank you. It is now well known that prior to 1996, there were 3 legislations which covered all of arbitration in India. The first legislation was for domestic, that was 1940 Arbitration Act. The second legislation was for old international convention, Geneva Convention, Protocol Act it was called. And the third one, 1976 Act, was the New York Convention, enforcement of foreign awards under the New York Convention Act. Between these 3, we covered domestic as well as international arbitration, foreign awards. 1996, ancestral model came in. The ancestral model is a model which is created by the United Nations, one of the subsidiary bodies of the United Nations called Ancestral, created a model law. A model law is not a treaty. It is not a binding obligation on the signatories. It gives them a suggestion as to what might be a good way forward. And in order to create a model law, the United Nations looks at different legal systems across the world and picks out all the best aspects of each system and tries to reconcile them and put it into one basket and offers it to everybody, saying that now, why don't you choose from this basket? So the Ancestral came out with a model law. India was a signatory to all these steps. And so India decided to adopt it. To a very large extent, we adopted it. No country is required to follow the model law entirely. Every country will have its own compulsions. It will have its own business environment. And every country has made departures from the ancestral model law. So have we. It is a structure, it is a framework, and based on that framework, you can now develop your law. This ancestral model laws have not only been used in arbitration, it is also the backbone behind the Insolvency and Bankruptcy Code, the IBC. That's also based on another ancestral model law. Now, the critical way in which the international community tried to consolidate the arbitration world was to focus on the concept of seat of arbitration. They said that if the seat of arbitration is your own country, then it is a domestic arbitration. If the seat of arbitration is outside your country, then it is a foreign arbitration. So having chosen this as the principal criteria, the attempt was made to now consolidate everything into one law. Therefore, we see that in 1996, the 3 acts are repealed, taken away. Instead of that, they are brought within the umbrella of Part 1 and Part 2 of one act. Part 1 deals with those arbitrations where the seat is India. Seat is India, mind you. It is not Calcutta, it is not Delhi, it is not Bombay. Seat is India. Yes. Very important. To my mind, this has been lost sight of in some judgments, as a result of which it is now sometimes incorrectly stated that the seat is Bombay or the seat is Calcutta. No, the seat is India. If seat is India, then Part 1 of the Arbitration Act applies. If the seat is outside India, then Part 2 applies. And you only legislate in India for the purpose of enforcement of the award which has been passed. You are not concerned with the process by which the award has come into existence. Whereas in Part 1, you are interested in every aspect of the award, because the award itself comes into existence and is controlled by your own legislative system. So we have part 1, seat India, roughly we can call that the domestic arbitration. Part 2, seat outside India, is foreign awards which have to be enforced in India. Now, commercial arbitration straddles this field. We cannot distinguish between commercial arbitration which is foreign and commercial arbitration which is domestic. So it became necessary, but at the same time, it is not the same as other domestic disputes. International commercial disputes are an important component of commercial disputes, but it is not the same as any other domestic dispute. International commercial disputes resolution takes place in outside India. It might also take place within India. International dispute resolution may take place within India because the seat is here. So therefore, they had to create a subcategory, and that subcategory is called international commercial dispute. It is an international commercial dispute if any one of the parties involved in this dispute is not an Indian entity, is a foreign entity. But if the seat is in India, then this kind of international commercial dispute is a domestic arbitration issue. So it comes in part 1. But if the seat is outside India, then it will be a foreign award issue and will go to part 2. Now, there are, when they classified all this in 1996, they made sure that there were not too many differences between the way in which international commercial disputes were resolved in the domestic environment and in the foreign environment. But as time passed, there was a understanding, there was a realization that you cannot equate or equalize everything between these two spheres. What is appropriate for international commercial dispute resolution, even if the seat is in India, is not appropriate for other domestic disputes. This was the realization. So 2015, one of the things that the amendment does is to emphasize the separation of these two also. So various aspects of the act relatable to international commercial dispute resolution was separated out from domestic dispute resolution. Just 1 or 2 examples. The principal court for an international commercial dispute is the High Court only, whereas for domestic disputes, it is the principal civil court of having jurisdiction under the Civil Procedure Code for determining that dispute. So the way that it is defined is that which is the court where you would go to file a civil suit if there was no arbitration agreement. If, let us say, Jabalpur is the court to which you would go in order to file a civil suit, had there been no arbitration clause, then the jurisdiction for an arbitration in respect of that dispute would be lie in Jabalpur. That is the way it was defined. The distinction now has become, it will only go to the High Court if it is an international commercial dispute, but it will go to the principal civil court if it is a domestic dispute. So to give an example, if it is a domestic dispute and it is roughly within the jurisdiction of, let us say, territorial jurisdiction of, let us say, Jabalpur, then it would go to the district judge of Jabalpur or whatever is the district within which it has to be decided. If, however, it is an international commercial dispute arbitration, having India as a seat, it will go to the High Court of Jabalpur. It will go to the High Court for the purpose of the decision, for the purpose of various things, enforcement, etc., etc. Second change was that when it comes to appointing an arbitrator or deciding whether there should be an arbitration staying at a litigation. Now, it will, if it's an international commercial dispute, it will go to the Supreme Court of India. If it is a domestic dispute, it will go to the High Court. Matters like this, various ways in which it was distinguished. Very important distinction was also drawn in the sphere of how much the court will interfere with the award, how much review will be carried out of the award under Section 34 of the Act. So, for instance, patent error or patent illegality on the face of the record is not available as a ground for challenging an award if it is an international commercial dispute, but is available if it is anything else, that is, if it is a domestic dispute. So, having created a uniform law for domestic as well as international commercial disputes, having India's seat, the feeling was that no, some distinction has to be made between the two. And that is what was achieved in the 2015 amendment to a very large extent. So this is how a revolution, almost an international revolution, has taken place from 1996 onwards, because most countries have now accepted the ancestral model in various ways, may not be exactly the same. Now, why is arbitration so important? Why is international commercial dispute resolution through arbitration so important? Because it is obvious that if a party from, let us say, Sweden and a party from India is having a commercial contract, now, if a dispute arises, is it better to go to the court in Sweden? Or is it better to go to the court in India? Answer is neither. It doesn't seem to be the correct thing to do at all. So that is why the better way of dealing with that dispute is an international arbitration. We then choose 2 arbitrators or 3 arbitrators now. Now it has to be a odd number. It cannot be an even number. Yes. You choose 1 arbitrator or 3 arbitrators or 5 arbitrators. You have that flexibility that people of both Sweden and India might be part of that tribunal. So they can consult each other and figure out what are the differences, what are the similarities, etc. And then you create a dispute resolution mechanism. Because we don't have international courts. In civil law, we don't have any international courts. There is an attempt to have an international court in criminal disputes, which has not yet been very successful, because that involves enforcement mechanism, police, etc., policing, investigation, etc. But still there is some concept. There is no concept of an international court of civil law. And when we think about the United Nations in ICJ, that is the International Court of Justice set up by the ICJ, by the United Nations, that is a dispute resolution mechanism between countries. It is not a dispute resolution mechanism which can resolve with any, in any way, a dispute between 2 private individuals. Of course, I'm speaking very broadly. There are situations now where countries stand in for private businesses through bilateral treaties. That is also something which goes into arbitration. But it cannot go into the ICJ dominion. So there is no international court to which you can take a dispute between a private individual in Sweden and a private individual in India. So you constitute your own tribunal, and that tribunal, you give it the powers that that will allow it to decide the dispute. And then you set up enforcement mechanism through which wherever be the country where the assets of one of the parties is, which is required for the purpose of enforcement, a mechanism must be there for recognizing the award in that country and giving effect to that award in that country.
Yes.
So this is the purpose. This is the purpose which we are now trying to achieve in this field.
Yes. Jaideep sir, you taught very lucid, very simple language about the arbitration, specifically international arbitration, and what is the purpose of international arbitration, और इंटरनेशनल कोर्ट ऑफ जस्टिस में खाली कंट्री ही जा सकते हैं एक दूसरे के खिलाफ, प्राइवेट पार्टी नहीं जा सकते, ये भी बहुत अच्छा आपने एक्सप्लेन किया। और इंटरनेशनल आर्बिट्रेशन फॉर्म कैसा होता है ये भी आपने एक्सप्लेन किया। मैं खाली दर्शक में नॉन लॉयर अगर है, अपने अपने थोड़ा सा माइक म्यूट कर लीजिए ताकि डिस्टर्ब नहीं होगा किसी को, तो उतना माइक म्यूट कर लीजिए। तो दोस्तों मैं खाली जो दर्शक हैं जो लॉयर नहीं है, मालूम ही नहीं है, उनके लिए खाली बताता हूँ ये आर्बिट्रेशन क्या होता है। तो जैसे कि हम रेगुलर कोर्ट में अगर कोई केस लेके जाते हैं तो रेगुलर कोर्ट में काफी समय लग जाता है, इसलिए बिजनेसमैन को कभी भी कोर्ट में रेगुलर जाने की जरूरत नहीं पड़नी चाहिए। इसलिए बिजनेसमैन, जब एक बिजनेसमैन दूसरे बिजनेसमैन के साथ एग्रीमेंट कर लेता है ना, तभी वो एग्रीमेंट में क्लॉज डाल देता है कि अगर हमारे में इफ एनी डिस्प्यूट अराइज बिटवीन अस, वी विल सॉल्व दिस डिस्प्यूट एज पर आर्बिट्रेशन। फिर आर्बिट्रेशन, कौन से आर्बिट्रेशन में जाएंगे, क्या करेंगे, वो सब क्लॉज में रहता है, बिजनेस एग्रीमेंट के क्लॉज में रहता है। फिर वो अगर है तो दोनों बिजनेसमैन में अगर कोई डिस्प्यूट तैयार हो जाता है ना, तो फिर वो आर्बिट्रेशन फॉर्म होता है, फिर वो डोमेस्टिक रहो या इंटरनेशनल हो। फिर एक पार्टी एक आर्बिट्रेटर अपॉइंट करती है, दूसरी पार्टी दूसरी आर्बिट्रेटर अपॉइंट करती है, और ये दोनों आर्बिट्रेटर मिलकर तीसरा आर्बिट्रेटर जो है वो अपॉइंट करते हैं, और तीसरा आर्बिट्रेटर जो रहता है वो प्रिसाइडिंग ऑफिसर रहता है वो आर्बिट्रेशन का। और ये आर्बिट्रेशन में लगभग 1 साल में ये मैटर खत्म ही हो जाता है। और ये जो अवार्ड रहता है, जैसे जजमेंट रहता है या डिग्री रहती है सिविल कोर्ट की, जजमेंट्स रहते हैं, वर्डिक हम बोलते हैं कभी कभी इसको, ये जैसा इन्फोर्सेबल है वैसा आर्बिट्रेशन का जो डिसीजन है वो इन्फोर्सेबल है इन द कोर्ट ऑफ लॉ। इसलिए बहुत इजीली ये मैकेनिज्म है। इंटरनेशनल लेवल पे, जब इंटरनेशनल लेवल पे दो कंपनियां एक दूसरे के साथ करार करती हैं और वो डिसाइड जब आर्बिट्रेशन के माध्यम से होता है, तो फिर उनका समय जो लिटिगेशन में जाता है वो समय उनको पूरा प्रोडक्टिविटी पर मिलता है, प्रोडक्टिविटी उनकी बढ़ती है, लिटिगेशन को समय कम लगता है। जस्ट आई वांट टू ऐड समथिंग, सो आई एडेड यू। नाउ आई asked to our Nani Palkhivala Wednesday Law Club's executive member, Advocate Chandralekha, PS Chandralekha. Chandralekha, are you there?
Yes, sir.
Yeah. Chandralekha will ask very fantastic question. बहुत अच्छे क्वेश्चन बाकी हैं, आप छोड़ना नहीं, एंडिंग पंच भी बाकी है। बंगाल, जयदीप सर ओरिजिनली बंगाल से हैं, हम बंगाल के बारे में भी, थोड़ी सी बंगाली लोगों के बारे में भी कुछ बातें जयदीप सर के साथ करना चाहते हैं। तो अभी चंद्रलेखा हु इज अ प्रैक्टिशनर लॉयर इन सुप्रीम कोर्ट ऑफ इंडिया, हम जितने भी गवर्निंग बॉडी है ये नानी पालखीवाला वेडनेसडे लॉ क्लब की, हम सब सुप्रीम कोर्ट में ही काम करते हैं। तो चंद्रलेखा इज अ यंग अमंग अस, और 5-6 साल से वो सुप्रीम कोर्ट में प्रैक्टिस करती है, बहुत अच्छे अच्छे केसेस भी उसने हैंडल किए हैं। एंड सी नाउ वांट टू आस्क सम क्वेश्चंस टू जयदीप सर।
Thank you so much for your time, sir. Now that we have broadly discussed about the subject of law that this particular webinar was about, we would come to a little informal discussion and kindly take us through the journey, your journey since childhood, and what were the factors that led you to decide to pursue law as a career, and even after that, how come litigation as a profession? Because after law, there were multiple options. So why litigation, and how you decided to take up law as a career?
So I come from a family where at least 3 generations ahead of me I can trace in the legal profession. My great-grandfather practiced as a pleader in the originally these were the courts of the Nawab, later on the British courts, in what is today in Bangladesh, in a place called Kumilla. And the interesting thing, and I have of course no familiarity with the gentleman, we have never even seen our lands which remained back after partition. But the interesting thing that I've heard about persons like him is that the court language of that day, of that time, was Persian, Farsi. And it was a necessary ability to practice in these courts that you must be fluent in that language. Not only your mother tongue, Bengali, not only maybe English, but also Farsi. You will find that our legal vocabulary in this country, across the country, is littered with words which are all of Persian origin, like wakalatnama, which is a word we use every day, like farman, all kinds of words are there which are all of Farsi origin. So this is the journey where it starts. As far as I know, I do not have any knowledge of what a generation before that did, but he definitely practiced in Kumilla. And my grandfather joined the judicial service and was a judge in the courts in pre-partition Bengal. And he was, of course, posted in different places. It was a transferable job. And he ended up rather farsightedly in Calcutta. He planned his affairs in such a way that his last posting was in Howrah, in the opposite Calcutta, across the river. And he was a district judge all his life. So therefore, he was part of the subordinate judiciary. He was very keen that his two sons become practitioners. And even though there wasn't that much money in the family, both the two sons were sent to do the bar exams in England, which was in those days a very prestigious thing to do. Both of them came back as barristers. Both of them set up practice in the Calcutta High Court. Both of them rose to the top of the profession. My father, Dipankar Prasad Gupta, who was the Advocate General of West Bengal, he came to Delhi as the Solicitor General of India. And as everybody does, they continued in Delhi till he passed away a few years back. My uncle, Bhaskar Prasad Gupta, also is a senior advocate who practiced in Calcutta and then later on practiced in the Supreme Court. And he also passed away very recently, unfortunately, under these COVID circumstances. So when I grew up in a residence in Calcutta where the ground floor was entirely a law library. And it was a law office, in fact, of not one but two lawyers. Two very prominent Calcutta lawyers functioned out of the ground floor of my house in Calcutta. And all day and all night, there was the clatter of typewriters going on because documents were being prepared from morning till night. And so therefore, I grew up in that atmosphere, watching people taking shorthand, dictation, typing, preparing drafts, getting ready for court, the library, the books, everything. And my grandfather always used to tell me that it was in my blood and it was impossible to escape from it. Of course, the next generation doesn't believe in that. They have made their own career choices. But I seem to have fallen into the trap, if I may say so, of remaining with what was in my blood. I studied economics in college. After schooling, I went to Presidency College. I studied economics because, as you know, in India, you cannot do law as an undergraduate program. There are countries in the world where you can do it as an undergraduate program. But my undergraduation was in economics. And then I went to Cambridge. I studied law there. I did the bar exams there. I came back, started practicing. And so here we are.
Very nice. और दर्शक को मैं ये बताना चाहता हूँ कि ये इंफॉर्मेशन को ऐसा ना ले कि भाई जयदीप गुप्ता सर के ग्रैंडफादर भी लॉयर थे, अच्छे जज थे, फिर उनके पिताजी सॉलिसिटर जनरल थे, इसलिए जयदीप गुप्ता को वो पूरा विरासत में मिला, फिर जयदीप गुप्ता सर इतने बड़े हुए। नो, जयदीप गुप्ता सर ने पूरा अपने अपने मेहनत के ऊपर बनाया है। और आप अगर फर्स्ट जनरेशन लॉयर है लाइक मी, मेरे जैसे आप फर्स्ट जनरेशन अगर लॉयर है, ऑडियंस में जो लोग हैं, वो याद रखिए कि इतना अच्छा काम कीजिए कि आपके जनरेशन, उसके अगले जनरेशन में कभी कोई नानी पालखीवाला या लॉ क्लब में जो कोई हमारा नेक्स्ट जनरेशन का कोई मुलाकात आपका लेगा, आपके थर्ड जनरेशन का, तो वो भी आपके बारे में हिस्ट्री बनाएगा। किसी न किसी को तो वो नींव रखना पड़ता है। वी हैव टू कीप वन स्टेपिंग स्टोन फॉर दैट, सो दैट वी कैन क्रिएट एक्सेलेंट एम्पायर ऑफ द सक्सेस इन लॉ फील्ड लाइक दैट। तो अभी मैं एक क्वेश्चन के लिए हर्षवर्धन सिंह राठौड़ को बुलाना चाहता हूं। हर्षवर्धन सिंह राठौड़ इज आल्सो प्रैक्टिशनर लॉयर इन सुप्रीम कोर्ट ऑफ इंडिया। ही इज आवर एग्जीक्यूटिव मेंबर ऑफ नानी पालखीवाला वेडनेसडे लॉ क्लब। और हर्षवर्धन सिंह भी एक सवाल, बहुत इंटरेस्टेड सवाल जो है, जिसमें सर को इंटरेस्ट आएगा, ऐसा सवाल हर्षवर्धन सिंह पूछना चाहते हैं। हर्षवर्धन सिंह, आर यू देयर?
Yes, good evening. Am I audible, sir?
Yes,
You are
yes.
audible, but you are not
Yes,
visible.
sir. Yeah, sir, some issue with the camera.
Okay, okay, no issue.
Sir, good evening to Jaideep Gupta, sir.
Good evening.
So, as we move forward with our webinar, in the last, I would like you to throw some lights on some of your interesting leading cases, which in which you have been your part of, and as well as the valuable experience. What are some of the valuable experience you have made in your journey that may help other law aspirants as well? So please throw some light on your leading cases, sir, if you could.
I started my career mostly with commercial litigation and writ jurisdiction work, because my senior in Calcutta did a lot of writ work. I came to Delhi and I worked for a few years with Mr. K.K. Venugopal, who is today the Attorney General of India. And he, of course, is known as a foremost constitutional expert of this country. So commercial work and constitutional work is the backbone of my practice, has been for most of my life. But in the Supreme Court, you find that you have to handle everything. So sometimes reluctantly, maybe, I have done criminal work, I have done revenue related matters, etc., etc. So it's been so long actually that it's very difficult to remember landmark cases in that way. But over one aspect which is entirely unexpected, I guess, but which over the last, I don't know, about 6-8 years, one after the other, litigation or disputes resolution arising out of Articles 25 and 26 of the Constitution of India, namely religious rights, freedom of religion, and the management of temples in India. It's a very unique opportunity that I got, one after the other. I don't know how it happened. Some kind of a spiritual design or whatever, that one got to do litigation or resolution of disputes in relation to the management and the legal constitutional aspects of one after the other temples in India, like the Sabrimala temple, where the whole process is still under litigation. The Padmanabha Swami temple in Trivandrum, the very famous temple in Guwahati, the Kamakhya Mandir. All of these, and of course, I played a fairly small role, insignificant role, in the Ayodhya dispute as well. All these cases ultimately hinged upon an interpretation of Article 25 and 26 of the Constitution of India. And it is a very critical part of our existence, I think, that we have to reconcile the religious rights of different parts of the population of this country, and how to reconcile them, how to create a harmony between them. And it is an area where the Indian Supreme Court has been magnificent. I mean, that's the only word. The way that they have crafted it over the years to achieve maximum harmony, to reduce disharmony, to create an environment in which it is possible to reconcile issues which may come into conflict with each other. This is one area which I recollect with great pleasure for having handled. I have done a very large volume of taxation and indirect taxation work, mostly for the government of India from time to time. A lot of them have resulted in judgments. When the service tax first came in, there was this judgment of in case of Laghu Udyog, Kalyan Mandapam, Tamil Nadu Kalyan Mandapam, and all that. When Mr. Solicitors was the Attorney General of India, and we were somewhere in the middle of the ladder, he used to pick us up specifically and send us to take care of different matters in indirect taxation, etc., etc. In commercial sphere, you see the Supreme Court does not do as much commercial work as, let us say, the High Courts of India does. So whereas that was the staple of what I did when I was still in Calcutta High Court, in the Supreme Court, occasions were not that frequent. But there have been occasions. There have been in arbitration law and in commercial law as well. So, I mean, I have this tendency of forgetting what has gone on even 1 year back. And if you ask me what is the most interesting case that I have done, I will only remember a judgment which has come today or yesterday or something like that.
Very nice, very nice, very good.
So in fact, even today, there is a very interesting judgment which has come out, which is in relation to an act which the state of Kerala had passed, which combined constitutional and arbitration law principles, because it was a legislation in relation to arbitration clauses and the competence of states and the Union of India to legislate in respect thereof. And that judgment has come today. And so if somebody says, what is the most interesting case you have done? This is the first thing which comes to my mind.
Very great. जो बहुत पहुंचे हुए लोग रहते हैं ना, वही इतने सिंपल होते हैं. कितने सिंपल तरीके से उन्होंने ये सवाल का जवाब दिया. कितने more than 500 केसेस के जजमेंट उनके नाम पे है. कितने सारे काम उन्होंने किया है. So this is a very great thing. Now I would like to ask one question. I want your message. One message to entire law students as well as law fraternity of India. What message you want to give for become a successful lawyer?
You see, there are certain aspects to the legal profession which are well known, which are inevitable, and therefore I do not believe I can contribute much by saying that. For instance, that you have to work and work and work and devote the greater part of your day and night to the profession is something that everybody knows, everybody will tell you. My personal focus, and something that I would like all law students in this country to have, is to conceptualize. A lot of us tend to treat law as a list of ideas or a list of facts or a list of things unconnected with each other. I believe in law as a conceptual subject. There has to be an understanding of the underlying concepts that we are dealing with. We have to understand that every area of law has principles, and we have to try and identify those principles, because only if you understand the principle can you tackle a new sphere, a new problem, because the whole idea is resolution of problems, isn't it? There is a dispute or there is a problem which has arisen. One of the ways in which we resolve problems in this world is to find a legal solution to it. Now that legal solution, to the extent that such a problem has arisen in the past, is maybe relatively easy to solve. You say, oh, in the past we have done it this way, let us do it in the same way in future. But very often the problem has never arisen in the past. It's unique. As we go forward, circumstances keep changing in such a way that every problem becomes unique. Even the same source may lead to a different problem, unique problem. How are you going to solve a unique problem? You can only solve a unique problem if you have certain principles in mind. You can't in every case say that give me a judgment and I will follow that judgment. Then what do I do? If there is no judgment to follow, then I have to look for principles. I have to look for concepts. And only by looking for concepts and principles and realizing that law is a subject of concepts and principles, only then can we truly be creative with the problem solving technique. It's a very creative situation. You cannot create unless you know what principles you are following. So a law student must not treat this subject as a list of ideas or facts or things. A law student must treat it as an integrated whole in which there are basic underlying concepts. And these concepts, even if there is no precedent, will help you to actually solve a problem.
वेरी नाइस बहुत बहुत मूल्यवान आपने सजेशन पूरे लॉयर्स को दिया है, और नॉट ओनली लॉ स्टूडेंट बट लॉयर भी अगर इसको फॉलो करते तो बहुत अच्छा होता है। और रोज 2 घंटा 3 घंटा पढ़ते रहो दोस्तों, सोने के पहले एक आधा तो भी जजमेंट पढ़ते रहो, रेगुलर टच में रहो लॉ के, और थोड़ा सा एनालिटिकल बनो। ये मोबाइल थोड़ा सा कम यूज करो, थोड़ा सिस्टमैटिक उसके इसमें मत आओ। बस ऐसे काफी कुछ सजेशंस लोग देते हैं अलग अलग। इसमें हमारे ये तीसरा पुष्प है इसका नानी पालखीवाला वेडनेसडे लॉ क्लब का। विकास सिंह का भी वीडियो आपको हमारे यूट्यूब चैनल पे मिलेगा देखने के लिए। उनका पहला पुष्प था, जो अभी हमारे सीबी के करंट प्रेसिडेंट चुन के आए हैं, लास्ट ईयर भी वो प्रेसिडेंट थे। और फिर रजनीश कुमार जो है, रंजित कुमार जो फॉर्मर सॉलिसिटर जनरल ऑफ इंडिया, वो उनका भी एपिसोड हुआ है, वो भी आप यूट्यूब पे दे सकते हैं। और ये भी एक कल तक यूट्यूब पे आ जाएगा। और इसका लिंक हम हमारे लॉ क्लब के ये वेडनेसडे लॉ क्लब के कुछ ग्रुप है, 1 या 2 ग्रुप, वो ग्रुप में हम इसके लिंक डालते हैं। अगर वो लॉ क्लब ग्रुप में अगर आप नहीं हैं ऑडियंस, तो कृपा करके आप वो लॉ ग्रुप के इसमें ज्वाइन हो जाइए। तो उसका लिंक रहता है, वो आपको जो मैसेज मिला है वो मैसेज में एंड में वो ग्रुप का लिंक है। वो ग्रुप से वो ग्रुप में आप ऐड हो जाएंगे ना, तो आपको हमारा ईच एंड एवरी इन्विटेशन आपको मिलता रहेगा, और आपको उसका वीडियो भी बाद में मिलता रहेगा। क्योंकि अभी जैसा मैंने आर्बिट्रेशन मैटर थोड़ा सा सिंप्लीफाई करके बताया था सर ने आर्बिट्रेशन बताने के बाद, तो उसके बाद हो सकता है किसी को इंटरेस्ट आए तो उसको वापस सर का सुनना है, तो ये दिस चांस इज अवेलेबल ऑन यूट्यूब पे। आप चाहिए वैसा उसको फॉरवर्ड कर सकते हैं। या कोई लॉ स्कूल में इफ वन असाइनमेंट इज गिवन, write a thesis or give the presentation, PowerPoint presentation on international arbitration, तो बहुत अच्छे पॉइंट अभी जैसे से अपने आज के प्रोग्राम में कवर किए। कमर्शियल कोर्ट क्यों एस्टैब्लिश हुआ है, बहुत अच्छे पॉइंट कवर किए। चलो अभी लास्ट पॉइंट में लेता हूँ। लास्ट पॉइंट मेरा एक है कि मैं इंडिया के साथ साथ मैं थोड़ा सा अलग अलग स्टेट को भी थोड़ा सा फोकस करना चाहता हूँ। वेस्ट बंगाल ये हमारा भारत का ऐसा स्टेट है दोस्तों, यहाँ से बहुत ही टैलेंटेड लोग तैयार हुए हैं और पूरे भारत में और पूरे विश्व में छाए हुए हैं। ऐसा दुनिया का एक भी कोना नहीं है जहाँ पे बंगाली नहीं है, हर जगह कोने में बंगाली है दोस्तों। मैं मेरा पर्सनल बताता हूँ आपको, मैं रोटरी क्लब न्यू दिल्ली का सेक्रेटरी हूँ और हमारे रोटरी क्लब न्यू दिल्ली में 2 पास्ट डिस्ट्रिक्ट गवर्नर हैं और दोनों के दोनों बंगाली हैं, एक आशीष घोष है और एक अशोक घोष है, तो दोनों के दोनों बंगाली है। तो बंगाली लोग बहुत ही टैलेंटेड रहते हैं, बहुत डिवोटेड रहता है, बहुत डेडिकेटेड रहता है। इसका मतलब बाकी राज्य के लोग डेडिकेटेड नहीं, ऐसा मत निकालिए। मैं बाकी राज्य का कभी स्पीकर आएगा तो मैं वो राज्य के बारे में क्या बोलूंगा वो आप समझ में आ जाएगा आपके। तो मैं आपको खाली नॉट ओनली वेस्ट बंगाल के बारे में, बांग्लादेश में भी काफी बंगाली है और इंटरनेशनल लेवल पे भी काफी बंगाली लगा है। सब बंगाली लोगों को आप थोड़ा सा प्रोग्रेस का, शांति का, लॉ अबाइडिंग का एक मैसेज जो है वो बंगाली भाषा में दे, ऐसे मेरी आपको रिक्वेस्ट है। जयदीप सर।
We jokingly say that whatever any Bengali thinks has already been expressed by Rabindranath Tagore. So we tend to quote him. I am not very good at remembering full lines of poetry and all that, but I'm very fond of his poetry and his music as well. And his philosophy is very inspiring to all of us. It has always been a message of peace. In fact, before the First World War started, he recognized that the European nations had reached a level of corruption. He called it a level of corruption, not financial corruption, but moral corruption, where it is bound to happen that there is going to be bloodletting amongst them. And he said that this cannot be avoided now. They have all brought themselves into a position where they cannot get out of it. So he spent all his life propagating his message of peace and how it should be achieved. If Jayprakash ji had warned me of this question, then I would have kept one or two of my favorite quotes, but the only line I can think of now is Ei Bharater Moha Manover Sagoro Tire, which means that the whole humanity meets in the shores of this great nation that is India.
Very nice. Very nice. और नेताजी सुभाष चंद्र बोस हैं, काफी बड़े बड़े लोग वेस्ट बंगाल से होके गए हैं और वेस्ट बंगाल से आके दिल्ली में आपने इतना अच्छा काम किया है, इतना अच्छा सुप्रीम कोर्ट है। यू आर वन ऑफ द ज्वेल ऑफ आवर सुप्रीम कोर्ट बार एसोसिएशन। एंड अभी का इलेक्शन भी आपके अंडर ही एसीबीए का हुआ है और उतने वो इलेक्शन में इतने बिजी रहते हुए भी यू हैव गिवन much time, so much time, many times I discuss with you of these things and you have given a very nice time. और मैं दर्शक को बताना चाहता हूं कि आप चिंता मत कीजिए, मैं भारत के एक लॉ की हस्ती को आपके सामने लाऊंगा और का आपको जो नॉलेज है नॉलेज शेयर करूंगा। इसमें हम लॉ मिनिस्टर को भी लाने वाले हैं, स्टेट के भी लॉ मिनिस्टर को लाने वाले हैं, फॉर्मर को भी लाने वाला है, रिटायर्ड जजेस को भी लाने वाले हैं, हाई कोर्ट जजेस, सुप्रीम कोर्ट जजेस। आहिस्ता आहिस्ता हमारा ये वेडनेसडे जो रानी पालखीवाला वेडनेसडे लॉ क्लब है ये अलग ऊंचाई पे पहुंचेगा दोस्तों। तो मैं यहाँ पे सबका बहुत बहुत थ्रू माय हार्ट आई थैंक्स टू यू, thanks to Jaideep Gupta sir. You have given your very valuable time for enlightening the people of India, enlightening the legal fraternity of India as well as the law students of India. And at last you have given a very nice quote of in Bengali language. And thank you very much. Thank you very much all. Chandralekha, Harshavardhan, Gurupreet, सबको बहुत बहुत शुभकामनाएं। अगले वेडनेसडे के लिए वापस तैयार हो जाइए। थैंक यू वेरी मच।
थैंक यू।